Hey guys, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We're going to go over Blake Lively's response in Texas court. So she had filed um, a motion to dismiss Jed Wallace's amended complaint. He responded to that, and now she's responding in support of her motion to dismiss. It is not 1,000 pages, so that's a good start. This is probably not going to be a very long stream because it is 100 and something pages, but most of that is they attach the ruling in the New York court to it. Sorry I'm late. I had some stuff going on. Okay, so I had to get a new phone. And I guess you can do this thing now where you just like put your old phone next to it and it's supposed to transfer over. But you have to like do this weird thing where you like take the camera of your old phone and like take a picture of like the little thingy on the new phone to make it work. And so I kept messing that up. So I was sitting here none of my devices are working because I'm trying to transfer everything. And I'm just like, what am I doing here? Taking pictures back and forth. Anyways, my phones don't work. It's my problem now. So yeah, not that you needed to know that, but I just thought everyone should know why I was late because after listening to me try to describe that scenario, you probably understand my frustration. It's very stupid. All right. And if you guys didn't see, there's going to be a public hearing on, what is it? Today's the 20th. So it'll be Tuesday, the 24th. And that's regarding something with the 2 tag employees that they're trying to get information from. So it'll be like a dial-in, but it's not like a thing that you can just like live stream. You guys know how that went down last time when Dave and I were, we'd never done this before. So we're not going to do that, but I will be talking about it afterwards. But you can dial in. I'll put the phone number and the code and whatever, like it's going to be on the docket, on the public docket. So I'll put it here so you can find it easily. But all you have to do is dial in from my phone. So, all right, let me pull up this thing we're actually supposed to be looking at here. And then after this, I'll also be streaming with Omar. It's around 7 p.m. Eastern. So in like 40 minutes on the other case with the fake pregnancy lady who keeps faking pregnancies to trap dudes, tries to get them to sign dating contracts. It's a pretty crazy thing. Let's see. Here we go. Zoom in a little bit. Lauren, I am so anal. I should have stopped right there. Lauren, I am so anal. I call Apple support at least once a week. They probably do not like me very much. Well, I blame you then. Just by association, they probably try to screw me over with the phone, right? Okay. Let's see if I can find where I want to start from. And a lot of this, remember, they're going to be arguing about whether it should be in Texas court, whether it should be in New York court. So we're going to skim over a lot of stuff here. All right. And the case stuff, of course, I skip over that until I'm going over it with Omar because I don't know what I'm talking about. So, all right. Ms. Lively files this reply in support of her motion to dismiss the First Amendment complaint and in response to plaintiff's opposition to the same. So remember, this has nothing to do with anyone in the New York court, really. It's just Jed Wallace is the only party related to the Wayfarer parties in Texas. So she's suing him in New York. He's suing her in Texas. All right. Neither plaintiff's amendment nor their opposition can save their defamation case against Ms. Lively, despite rewriting their initial complaint and redesigning their original claims. Plaintiffs still have failed to demonstrate that Texas is the appropriate venue or jurisdiction for their claims. It is not, or that their defamation claim can survive their failure to meet basic pleading requirements and the multiple applicable privilege that bar it. So she's going to argue that the, sexual harassment reporting privilege or whatever it's called is protecting like the stuff that she says here, or that she said that he alleges defamed him, which should that be a thing? I'm going to say no, especially because he's never met this woman. He's never harassed her in any way, never spoken to her, nothing. So I don't really think that it should, but does the law allow that? Maybe. I'm not going to be able to answer that for you today. That's for sure. Okay. As to venue, the first to file rule demands dismissal and deference to the New York litigation, which involves identical facts, witnesses, and questions of law. By asserting a defamation claim against Ms. Lively based on statements made in her CRD complaint, plaintiffs have put directly at issue the truth of Ms. Lively's allegations, which are already subject to litigation in New York. Moreover, until June 9th, when the first filed court dismissed their defamation claim with prejudice, right, okay. The New York Wayfarer plaintiffs asserted a defamation claim based on the exact same legal theories as plaintiffs here. Even if they could overcome the first to file rule, which they cannot, plaintiffs grasp at straws to establish venue and jurisdiction. The events giving rise to the alleged defamation occurred outside of Texas, and Ms. Lively's prior Rule 202 petition, which was never even served, cannot support either venue or personal jurisdiction over her. As for the merits, the FAC fails to state a claim as a matter of law, including because the statements at issue are protected by the same litigation and fair report privileges that the first filed court already found doomed the defamation claim of the New York Wayfarer plaintiffs. Hold on. I don't know if that's really... Yeah, I mean, I guess I see what they're saying. Okay. My issue is I don't like it, okay? I don't like it. So whether or not you feel like that the judgment was fair or correct is going to kind of paint your picture of this, I guess. Okay. This case should be dismissed under the first to file rule and because venue is improper. So we're going to skip a lot of this stuff because we've seen this like over and over again. Okay. The first filed court dismissed the defamation claim against Ms. Lively with prejudice under California law, holding that statements in the CRD complaint alleging harassment and retaliation are protected by the litigation privilege, and the actor providing the CRD complaint to the Times is protected by the fair report privilege. And that's extremely, extremely annoying to me because, like I said, she's never even met this guy. He's never laid eyes on her in person. They've never spoken to each other. And if, as he said in his sworn affidavit, he only did like monitoring social media, he didn't actually publish anything about her or anything of the sort, then it's kind of stupid, in my opinion, that, you know, she could use that to protect herself from his defamation suit. Okay. The first to file rule requires the court to defer to and avoid interference with the first filed court, which has already adjudicated virtually identical allegations to those at issue in this lawsuit. The opposition ignores and therefore concedes that the New York litigation's now dismissed defamation claim is virtually identical to not only the defamation claim asserted here, but also that previously asserted in the California complaint. Plaintiffs mount a single argument with respect to the obvious overlap among these claims against Ms. Lively, that the New York litigation plaintiff's lawsuit was about what Ms. Lively purportedly did to 6 of them, and not to the plaintiffs by virtue of them choosing not to be plaintiffs in the New York litigation. So she did not sue him in New York at first. She sued him, or she sued the Wayfarer parties in New York. She left him out of it. And then he sued her in Texas. And then she decided to, you know, add him to her First Amendment complaint as one of the defendants in New York. So it is a little bit confusing to me. But the first to file rule does not require a complete identity of parties. It applies whereas here there is the likelihood of substantial overlap between the core issues, proof, questions, or subject matter. Separately from the New York Wayfarer plaintiffs' now dismissed claims, the first to file rule also requires dismissal because the New York litigation against the plaintiffs and the other New York Wayfarer defendants is proceeding apace. What does apace mean? You guys know there's always going to be like a word or two that I'm just like, I've never seen this before. Yeah, I said that right. Okay, that's what I thought it meant. So that's cool. It means like quickly, swiftly. Ignore me. No, don't. Okay. Plaintiff's role in that campaign is a central issue in both the CRD complaint and the New York litigation. Ignoring that fact, plaintiffs incorrectly claim that this case is about the false accusation that they were involved in the predatory conduct on the set of the film. I mean, they kind of make it sound like that, yeah. She certainly makes it sound like that. Plaintiff's argument overlooks their own pleading, which alleges that the CRD complaint contains defamatory accusations that plaintiffs engaged in a retaliation campaign. For example, the exact conduct at issue in the New York litigation. The veracity of the statements about plaintiffs' participation in the retaliatory scheme is the core issue in both cases, and the proof adduced would be the same. Thus, there is unquestionable overlap between the two cases. Even if the CRD complaint accused plaintiffs of sexually harassing Ms. Lively, which it plainly does not, I mean, it's not that plain depending on who you ask. So like a lot of this is just how it seems to the public, especially for this guy who he's saying that his business, this is going to cause a lot of problems for his business. Um, it doesn't look that way to most people who are reading this, but at the same time, you have to realize this is all happening in like the court bubble. So what I think doesn't necessarily mean anything, but it is how it looks to me. So, one sec, guys. K Fitch says it accuses him of being an abusive ass, and he has lost business. I agree. I agree with that. So, even if the CRD complaint accused him of harassing, okay, yeah, that would not change the fact that the court issues proof and questions are central subject in New York litigation. Okay. The opposition does not even attempt to address plaintiff's admission in the original complaint that they filed this case in Texas because they were threatened with liability and hoped for an early adjudication without waiting until Miss Lively should see fit to begin an action against them in New York. Such a race to the courthouse shortly after dodging service for pre-suit discovery should not be rewarded by this court. And if you remember correctly, or if I remember correctly, rather, I don't know why I said you, he apparently had some sort of cardiac event while she was trying to serve him. And so that was a whole issue. So I don't know. It was kind of, I remember everybody's talking about that because it's like she put 2 men in the hospital, just like being an absolute terror, which is kind of funny. Not funny that they were in the hospital, but funny that she's like making herself look worse. You know what I mean? She's trying to prove that she's not like some stuck up asshole. And then she's like, let me just put 2 guys in the hospital because of stress. All right. Venue is improper because, as plaintiffs concede, a substantial part of the events giving rise to the claim did not occur in this district. We're going to skim over this because, again, we've seen this like a million times. Okay. No, I remember this. Okay. The court lacks personal jurisdiction over Miss Lively. The Rule 202 petition does not subject Miss Lively to personal jurisdiction. Okay. Plaintiffs failed to address that the filing of that petition and non-suit 14 days later without ever serving Mr. Wallace does not constitute litigating extensively on the merits. Instead, plaintiffs attempt to argue that the Rule 202 petition is akin to an original action because it sounds inequity. But they offer no authority for that proposition, including the one case they cite, nor do plaintiffs attempt to distinguish the cases that Miss Lively relied upon holding that a Rule 202 petition does not constitute an original action, except to say that Halliburton Emergency Services versus Ironshore Specialty Insurance Company is not applicable as it involved filing responsive pleading conditioned on a jurisdictional challenge. And I'm not going to lie to you, I didn't read this, so we're going to skip that. Because I'm not reading all these cases, man. I got a job. Shit. Plaintiffs also fail to address that even if the Rule 202 petition constituted an extensively litigated original action, it still would be insufficient to establish specific jurisdiction because this lawsuit does not arise out of the Rule 202 petition. Plaintiffs cite no authority supporting the notion that an unserved Rule 202 petition confers jurisdiction over Miss Lively in a separately initiated lawsuit. The CRD complaint is not directed at Texas. Plaintiffs argue that personal jurisdiction is proper under Tavas and Calder. Okay, let's see. Tavas should not go, and I'm not even sure if I'm pronouncing that right, should not guide this court because it involves a breach of contract claim that arose out of defendants who directed a tax return filing to the state of Texas and thereby conducted business in the state of Texas, knowing the filing would be sent to Texas. By contrast, plaintiff's defamation claim arises out of Miss Lively's filing the CRD complaint in California and allegedly sending it to press located outside of Texas. Allegedly. Oh, okay. Sending it to press located outside of Texas. Unlike the defendant in Tavas, Miss Lively neither directed her conduct to Texas nor conducted business in Texas. Plaintiffs claim for the first time in their opposition that Miss Lively is subject to jurisdiction in Texas because she contracted with Texas process servers. But unlike in Tavas, this case does not arise out of that alleged contract. One sec. Plaintiffs rely on the fleeting, non-material reference in the CRD complaint that Wallace is based in Austin, Texas, but such a collateral reference to Texas does not confer personal jurisdiction. Even so, plaintiffs were not exclusively tied to Texas. After all, Street was a California corporation at the time, and the impact of plaintiffs' work, which factually underpins the CRD complaint, was felt in California. Jurisdictional allegations made on information and belief that occurred after the complaint was filed do not establish personal jurisdiction. Hang on. Yeah, we're going to skim over this. Honestly, I know that they have to do this back and forth, but it does start to feel like beating a dead horse after a while. I think because they went through all this and then he amended the complaint and now we're going through all this again. So it's like, ugh. What are your thoughts on JV lawyering? Who's JV? Help. All right. Plaintiffs fail to state a claim for defamation. Plaintiffs confirm that they complain of two publications, the CRD complaint and the draft complaint, which were filed and published to the media. By so doing, plaintiffs have abandoned their freshly derived claim that the information and belief statements defamed them. Accordingly, the court need only consider whether the FAC states a claim for defamation based on statements contained within the CRD form and the attached CRD complaint. It does not for the reasons stated in the motion and below. Okay. The FAC does not comply with Rule 8. Plaintiffs gloss over Ms. Lively's argument that the FAC does not comply with Rule 8. They include a single footnote on the topic, claiming that the case cited in the motion is inapplicable, and that the FAC complies with Rule 8 because it specifically alleges that Ms. Lively provided all of this information to the report and to the newspaper. They ignored that their own pleadings defines Lively to include any number of unspecified people, including anyone at any of the corporate entities that she or her husband owns. Okay. And fails to include any allegations either with respect to any specific statements published or that demonstrate agency. As far as their attempt to distinguish, I'm going to skim over this actually. Plaintiffs ignore Ms. Lively's reliance on other jurisprudence, including from this district, that requires far more specificity to comply with Rule 8. Okay. Plaintiffs concede that the complaint does not plausibly plead any statements capable of a defamatory meaning. Okay. Plaintiffs fail to confront Ms. Lively's argument that the FAC fails to state a claim for defamation by implication because the inference on which it is based, that a reader would view the caption of the CRD form and attached CRD complaint and infer that plaintiffs engage in sexual harassment, is unreasonable. I mean, I disagree with that, but that's just me. Plaintiffs have thus abandoned their implied defamation claim by failing to defend it. And they rest their case solely on the challenge statements at FAC 29 and 30. Plaintiffs' response to the argument that the allegedly defamatory content is not more damaging than the admitted truth misses the point. Plaintiffs assert that it would be detrimental to their name to falsely accuse them of weaponizing a digital army in retaliation for reporting sexual harassment. I mean, what? What is the problem with that? That feels like an accurate statement. But the admitted truth is that Ms. Lively reported sexual harassment to Wayfarer, which prompted TAG to approach plaintiffs about engaging in a social/digital mitigation or remediation campaign on behalf of Wayfarer, which prompted plaintiffs to, in fact, perform a job for Wayfarer, TAG, and Baldoni. All right, let me unpack that real quick. I disagree that she reported sexual harassment to Wayfarer, obviously. I disagree with that. It was more of a threat. It wasn't like I'm reporting sexual harassment. It was like, do this or I'm going to tell people that you sexually harassed me. That's how it reads to me. So obviously you guys know where my bias is. So, okay. Prompted TAG to approach Jed. Okay. But he says that the job he performed and the things that they signed on for, it was just monitoring. It wasn't actually what she's describing it as. I don't know if that matters, unfortunately, in court, but it matters to me, you know? In other words, plaintiffs admit that Wayfarer hired them to engage in a public relations mitigation and remediation plan in direct response to Ms. Lively's reports of sexual harassment. That's not actually what happened, though. There is no difference between that truth and the alleged defamation. That's not actually what happened. No, not at all. No. She unfollowed him and was doing all this stuff with the cast and everything out in the public, promoting the film, and she refused to let him participate in that. And she banished him to the basement at the premiere and had all this stuff going on to where he's like, well, this is not good. I'm going to need to kind of protect myself and my image here. We're going to need to be prepared to, or at least know what's coming. We're going to need to know what's coming so we can prepare to help whatever damage she's going to do, I guess. I'm not describing that very well, I know. But she didn't say anything about sexual harassment until the CRD complaint in December. So no, it was not in direct response to her reports of sexual harassment. He was signed on in August. What are you talking about? Okay. There is no difference between that truth and the alleged defamation. Again, I really disagree with that. Plaintiffs failed to sufficiently plead fault. Okay. They further failed to overcome that the FAC does not plead any facts demonstrating that Ms. Lively should have known that plaintiffs did not assist the Wayfarer parties, Tag, Nathan, and Abel in the retaliatory efforts to bury her. Really? Nor can they. The first filed court recently considered a similar considered a similar allegation in the New York litigation, holding that there's no basis to infer anything other than that. Ms. Lively filed her complaint in that case based on the CRD complaint in good faith. And again, on its face, it's like, yeah, you could say that, but it's just so obviously not true to me, because you could easily prove that if you just have to show, but you don't, which is frustrating. There's no way to prove it at this point, but it doesn't mean it's not true, I guess, is what I'm trying to say. The only fact to which plaintiffs point with respect to fault is the Rule 202 petition. However, plaintiffs do not address any of the arguments in the motion, including how the act of filing the Rule 202 petition after publishing the allegedly damning defamatory statements, well, I'm meaning both maybe, statements possibly could demonstrate state of mind at the time of publication. For the same unrebutted reasons explained in the motion, the Rule 202 petition does not support a finding of negligence. Hey, Cass, how's it going? 1 second. Zach, what are you talking about? Oh my God, my phone is alive. It's actually working now. That's great. Now I can spam text Bruce. Okay. Plaintiffs have failed to sufficiently allege defamation per se, which means they must but have failed to plead they must but have failed to plead damages. That was confusing. Plaintiff's defamation per se hinges on arguing that Ms. Lively accuses plaintiffs of sexual harassment, but the CRD complaint speaks for itself and does not include any accusation that plaintiffs engaged in sexual harassment. Plaintiffs claim that accusing Wallace of weaponizing a digital army harms him in his profession is not credible, since he has built a book of clients by doing just that to help his clients mitigate crises. Huh? Accusing him of weaponizing a digital army harms him because, okay. But if that's not actually what he did, he's built a book of clients by doing just that. Wait, where are you getting that from, though? Can you show your work on that? I'm not saying that's not true. I'm just saying, where are you getting that from? Can you show your work? Because he's never advertised himself as such, to my knowledge. That's just kind of what she accuses him of being. So, indeed, plaintiff's ability to weaponize a digital army and launch the type of social media campaign they did with respect to Ms. Lively could be good for plaintiff's business. Oh, thank you so much, you stupid bitch. I'm so sick of this. My God. Wallace admits that the real harm to his profession is not what Ms. Lively said, which he must prove to state a claim for defamation per se. but rather that his work for the Wayfarer parties has lost its cloak of anonymity. I mean, that is super fucking important to this job. That plaintiff's covert actions are now the subject of litigation will also, like, huge media pieces, okay, does not make Miss Lively's CRD form and attached CRD complaint defamatory per se. The problem is you lied in it. You lied in all of it. I'm so sick of this. Plaintiffs attempt to show that they have sufficiently alleged damages by pointing to vague allegations projecting at $1 million loss fails. Plaintiffs do not and cannot point to any factual allegations demonstrating how the allegedly defamatory content caused such alleged loss. The CRD complaint is privileged under California law. I mean, we've heard all about that at this point, so I'm not gonna go through that. Plaintiffs concede that the litigation privilege protects the statements in the CRD complaints. Okay. How did they concede that? Plaintiffs concede that the statements are protected under the litigation privilege in California law, which is consistent with the first filed court's holding. Plaintiffs argue that the litigation privilege under California law does not protect press releases. Plaintiffs never allege that the CRD form or the attached CRD complaint are press releases, or that Lively or her agents issued a press release that included allegedly defamatory statements. Thus, the California cases cited by plaintiffs, none of which concern communications made in a judicial or quasi-judicial proceeding, do not apply. Moreover, that Ms. Lively or her agents may have leaked the CRD complaint to the public has no bearing on the applicability of the litigation privilege. I know it doesn't. It might not. I mean, but I kind of feel like it should. I think that's bullshit. Just generally speaking, this is bullshit. Like, you should not be able to do that to somebody, because then it just turns into a weapon, and it's not something that's actually used to protect people. Maybe in a lot of cases, it's used to actually hurt someone, and then be like, "Look, I have a shield, so you can't do anything about it." That's kind of fucked up to me. And I know people will say, like, well, most cases, the person in question is not going to be lying. But in some cases, it's worth sacrificing the people involved in the few cases that the person is lying. And I'm just kind of like, okay, would you be saying that, though? If the sacrificial lamb was your dad, your husband, your son, I don't think so. As long as it's a stranger, you're fine with it. But you start putting real people in here and you realize the effect it has on real people. I look at that quite differently. So, especially when it's used by somebody with such, like, money and status as a weapon. Give me one sec. This is something I've thought about, because somebody points out here, because her 17-point list says no retaliatory anything. But if he really was, like I said, just as he swore in his affidavit, just monitoring trends on social media, whether or not that's true, I couldn't tell you that, but he did say that in his sworn statement. If that's true, then where's the retaliation? It's just social media monitoring, So I find it hard to believe that could be retaliatory. But I know I've had the same question a bunch. All right. The fair report privilege under common law and California law shield Miss Lively from liability for allegedly sharing the CRD with the media. Again, with allegedly, like, we obviously shared it with fucking media. I mean, didn't Megan Twohey do an interview with NPR where she basically said as much? The first filed court confirmed that the California fair report privilege applies to Lively providing the complaint to the Times because it is a communication to a public journal of statements said in the course of an official proceeding. The court explained that in 1996, the California legislature extended the privilege for this exact situation to protect individuals who communicate litigation statements to the press. Again, I do not like that, actually. It's like, I get it, but at the same time, it opens the door to some pretty bad stuff. The sexual harassment privilege protects Miss Lively's statements. Plaintiffs argued that the sexual harassment privilege does not apply because Wallace has alleged actual malice. In that one statement, that plaintiffs weaponized the digital army around the country from New York to Los Angeles to create, seed, and promote content that appeared to be authentic on social media platforms and internet chat forums is not covered by the privilege. Plaintiffs ignored that the sexual harassment privilege protects statements about not only harassment and retaliation, but also aiding and abetting the same, including by executing a social combat plan. Further, plaintiffs do not adequately allege that Ms. Lively made the statements even with negligence, let alone actual malice. Moreover, the broad immunity provided by the sexual harassment privilege covers that one statement because it is related to an incident of sexual assault, harassment, or discrimination, which is why it is included in the CRD complaint. Filing a CRD complaint does not mean there's any truth to your allegations. That's what frustrates me so much. And then, of course, Ms. Lively respectfully requests the court dismiss this case with prejudice and award her attorney's fees and costs. And this is just the ruling that they were referencing to. So that was the whole thing there. Okay. Was the defamation claim against Blake also made by the other Wayfarer parties? I can't remember now. Well, this is like a separate case where he's included as a defendant with the Wayfarer parties in New York, but in Texas, he's the only one making these claims. So it's like there's some similar stuff in there because obviously he's saying some of the statements that she made to the press and all that were. I totally lost my place. My ADD is like wild right now. The statements that she made to the press and stuff were defamatory towards him, which is, some of what they were also saying. So it's not like the exact same because a lot of what they were saying doesn't apply to Jed at all. So he hasn't raised the same issues, but yeah, hopefully that answers your question. So like they probably raised the same claims, but they also raised a lot of other issues that he has not raised here. So, and also his role in all that was just like super different. Cassidy says, when trying to track down a smear campaign, you start with posts or comments you think originated there and trace them. Comments about Blake come from actual people with actual content. No, they're all bots, bro. Come on. All right. Well, guys, I got another stream in 10 minutes with Omar regarding that other case. So I'm going to close it out here. It'll redirect you to that one if you want to stick around for it. If not, I will see you guys next time. Thanks, everybody. Sorry to rush out, but I've got to take a little break before that. I only got 10 minutes. So see you soon.